India Inc. has been dealing with a flurry of GST notices, and it's not just the gaming industry. Of course, it's the gaming industry that hit the headlines last week with tax notices of huge proportions. In many cases, the demand for tax unpaid, as claimed by the GST authorities, was even larger than the total revenue of the companies. But it's not just gaming. There have been tax notices going out to companies like ICICI Lombard, Maruti, and many, many more. Now, what exactly is going on? Why have we seen so many notices coming in by the end of September? Of course, in a lot of these cases, the demand has been challenged in court. Will these claims actually stick? We're going to be breaking down this story, and I have two excellent legal experts with me. But first, I'm going to go across to my colleague Janani, who has been tracking these details, speaking to experts and including those in the finance ministry to understand what really the reason is. So, Janani, why this hurry to send out so many tax notices, especially before September 30th?
That's right, Tamanna. As you pointed out, there is in fact a spate of notices that have gone, and it's not just particular to the gaming industry, as we would have seen perhaps in the case of Delta Corp or Dream 11. It's also to insurance companies. It is also to individual taxpayers. And I would like to bring out that there is a common thread, which is we have to notice the period of the notice that is being specified and the charges that are being levied. Now, the period of notice in almost all of these cases starts July 2017 from the implementation of GST till the period of 2022. And the charges have been mostly under Section 74 of the GST Act. Now, the jargon of that is a willful miscalculation or a suppression of details with an intent to evade taxes. Now, it's important that this section is pointed out because it comes with a timeline that any adjudication on the matter needs to be intimated by the 30th of September, and by the end of this particular calendar year, it needs to be adjudicated, or at least the proceedings must begin on that account. So that could be one of the possible reasons that we're seeing a spate across industries. Now, gaming has come more into the limelight, particularly because there is an ongoing issue with respect to the Gamescraft's particular case, whether it is going to be on which part of the levy. Is it going to be on the 18% that they used to pay for this past period, or is it going to be the 28% that was clarified in the 51st GST Council that happened in August? In fact, that time the Finance Ministry said this amendment is clarificatory in nature, which means this has always been the case perhaps. Yeah. So whether this would weigh in on the upcoming GST Council meeting is also something we have to see.
That's important.
But back to you.
That's important. Janani is going to be tracking that GST Council meet, which will take place on 7th of October. So that's important. Also, just an addition, when we're talking about gaming, the federation, that is the All India Gaming Federation, has written to the Finance Ministry saying that don't start implementing this 28% tax, which started from 1st of October. So it's actually in process right now. Their argument is don't implement it because there are at least 15 states right now that haven't changed their laws yet or haven't amended their laws yet. And as per the Supreme Court order, you can only start collecting this tax when state and center are on the same page. So that's once again another bit as far as the gaming industry is concerned. But like we said, this is a larger issue. So what's going on? Badri Narayanan, executive partner of Lakshmikumaran and Sridharan partner attorneys, is with me. I'm speaking with Abhishek Rastogi, lawyer and founder of Rastogi Chambers. Welcome to both of you. Great to speak with you on BQ Prime. I'm sure this GST notices are keeping both of you very, very busy. That's why I'm seeing that big smile on Abhishek Rastogi's face. GST notices are great news for lawyers, isn't it?
I think it's I think there has to be a balance with what sort of notices are coming. And as we speak, I am defending for petitioners here in Goa, speaking from Goa. But I think to answer to the question that why this hurry is happening, I think the answer is threefold. One is on the judicial side. If you see the gaming aspect, the gaming decision of Karnataka High Court and the Supreme Court. Now, because there is no stay on the order and the revenue has got an advantage because there is no stay and nothing. So, a lot of these demands, etc., are now taking place. Show cause notices are being issued because Supreme Court has tilted in favor of the revenue. So that's on the judicial front. On the technical front, yes, Janani spoke a very valid point that a lot of these notices may become time barred. and extended period of limitation, malafide intent, etc., will have to be proved. So from that perspective, also there is a hurry. The last but not the least could be, we are running towards the election year, and there are pressures with respect to targets. We need to see the economic front as well, as far as fiscal deficit and GDP to tax ratios, etc., are concerned. So I think all of these cumulatively is leading to a lot of this issuance of these notices, demands, course of recoveries, whether for gaming or for insurance companies or otherwise. And I think in next 3 to 4 months, yes, of course, they will keep us on the toes. The advocates will be on the toes.
Okay, advocates are on their toes. I don't know how much of the fiscal deficit is going to be reduced by these astronomical notices, because someone has to be able to pay them as well. Before that happens, it will all go to court, like it has in a lot of these cases. Badri, what's your take? How many of these are going to stick? And let me start specifically with the gaming part of it. Now, it's been made very clear that the tax rate is 28%. It's going to be on the upfront amount that a patron buys to play any of these games. There is no differentiation been made between game of skill, game of chance. This is the money that has to be paid. Is that the end of the story as far as the gaming industry is concerned, or do they have the legal room to make a case that they should not be applied, the tax should be applied not in this manner?
Thanks, Amanna. And like I said, always pleasure to be speaking with you and Abhishek, my good friend. So I'll just come to the gaming industry. I think, like you said very nicely at the start, sometimes the tax demands are much more than the revenue that these companies are collected or have collected. I'm always for a situation where the law is clear, and even if the tax is a little bit higher, if the industry is clear and is able to adjust for it and be able to determine based on that, to pay that tax should not be a problem. However, I feel for the past period, what the demand is being sought by the department, based on what they think has been an amendment or a clarification issue now, is a bit excessive. Okay, in terms that they are really trying to tax the gaming industry on what they call as contest entry amount, which is the entry fee that you pay for the purpose of paying the tax, which includes the prize pool, which is never part of the revenue or the books of the gaming company. The gaming companies earn money by providing platform fees and platform services. And so they've been paying 18% on that. You pay 28% on that, we have no problem, clarified, not an issue. But effectively tax the entire price pool, and that also on a retrospective basis, because you are saying that it is now clarificatory, while we know for a fact there have been audits that have taken place, there have been reviews that have taken place, and there have been adjudications that have taken place, which have basically said that the price pool is not taxable. So I don't know how much this is going to stick, but having said that, the core issue which is coming up before the Supreme Court, and we were part of the GameStop litigation, is really whether real money gaming is a game of skill or game of chance, but more importantly, whether the way in which it is played online, will it convert a game of skill into a game of chance, which I think is a more fundamental, and it goes to the root of not just tax, but of other areas of law. So it'll be interesting to see how this is. My own sense is that probably this will be even if it sticks, and I hope it doesn't, and I'm pretty sure there are good reasons not to. It's probably going to have a huge impact. I don't think they're going to be able to collect these amounts from these companies. Companies are not going to be in a position to be able to pay this. So I really don't understand the rationale behind this, except to say that this has been our stated position and this is our policy. So this is where I am on this. It will be interesting to see where it goes. Hard for it to crystallize and recover, and maybe harder for it to stick.
Okay, so let's take this conversation a little beyond just the gaming industry. The positions are pretty clear and fairly well known as far as the gaming industry is going. And let me come to you, Badri, with the question I asked Abhishek. Why now? Why the quantum? And clearly it's beyond gaming. In terms of the companies and sectors which are getting notices. There are reports of individuals getting notices. There's some reports saying that these are AI generated. I don't know if that's true or not. But what's your take? What's your take about why this is happening now in such great numbers? Or is this par for the course?
I think the one thing we need to understand is that there's been a pent up demand or pent up period where these demands should have been kind of crystallized and brought through. For the reason that we've been seeing for the last couple of years, especially post-COVID 2021 onwards, a lot of investigations taking place in a variety of industries. We've seen investigation take place in the insurance industry, in the auto industry, in the EV industry, in pharma industry, okay, in healthcare services. So many areas we've had investigations going on, and all of these investigations had reached a stage where they had reached a stage of issuing of notices, but they were all waiting for it to go out. For the reason that there is a period of limitation which applies to the adjudication of these notices by a certain period for every financial year. So for the period 2017-2018, the latest date by which the adjudication can take place is end of this year, 30th December 2023, and they have to give a mandatory 120-day period of notice before it can be adjudicated. Hence, 30th September 2023 was an important date by which they had to issue notices for them to be able to crystallize these demands. If they missed this date, then these demands basically became time barred. And so all of this pent-up investigation, issues, position that the department was taking has all got crystallized because we've reached that stage where the date for adjudication got set and the department was forced to basically issue. And we're probably going to see this on a yearly basis going forward, where every year, based on whatever other positions and issues which are there, are probably going to be issued around about this time or earlier in the year, and there will be an adjudication around about September to December every year. And that's how we were probably going to see these cycles go through going forward.
Okay. Now, the thing with adjudication is, and we talked about how many of these cases will eventually stick, where they will go in court, and I'm coming to Abhishek Rastogi with this question, is that it still costs the company or the entity that is the recipient of the tax notice to even fight it in court, isn't it? They have to deposit 10%. And that will hit cash flows. What is the impact there from the company's point of view?
See, I think you are bang on the point. If these demands are confirmed by the lower adjudicating authority, the pre-deposit amount under the GST regime is significantly higher than the pre-GST regime. Here, till tribunal, it will be 10% plus another 20%. So 30% goes out, and this is 30% of the tax amount. So what has happened in a lot of these cases is that what Badri mentioned, that, a lot of these notices are now being issued in haste because to meet these deadlines. And in that process, what has happened is that the pre-show cause notice consulting has not happened in a lot of cases. In a lot of these cases, they are saying you pay this, even at the pre-SCN consulting stage. Now, of course, that we understand in law that this is discretionary because the word shall has been replaced by the word may now. But Supreme Court in plethora of cases have held that even when these are discretionary, you have to be very cautious that how this discretion is to be exercised. And if you see a lot of these notices being issued to insurance companies or to the gaming companies recently, they have not used that discretion appropriately. And that is one more reason or a ground because of which these petitioners can go to the court and say that this discretion has not been exercised appropriately. So I think that has been done in haste to meet these deadlines. And of course, the hard part of it would be the litigation cost, which would be high amount and percentage of pre-deposit. And hence there have been representations made to North Block that in absence of these tribunals and for the notices which are of higher value, let there be reconsideration of the percentage of pre-deposit and get this percentage at par with the pre-GST regime.
Yeah, no, absolutely, because the process is going to become the punishment and could really be untenable. Okay, broad question before we wrap up. About 7 years now since GST became a part of everyone's life, and I'm going to come to Badri first on this. We are still working through these kinks in terms of what is an evasion. There are many subheaders under which these tax notices have come: related party transactions, input tax credit, and it's not just in small amounts. It's not just smaller companies. There are large enough companies with large compliance teams who are also getting these notices. What is it telling us about how well GST has settled in? I mean, we celebrate the high collections every month. That's a good sign. But what is it telling us about, the nuts and bolts of how the system's working?
So, Tamanna, one thing you need to understand is that we have the most complex GST system in the entire world. Okay, we have a federal GST, which probably has been experimented in no other country, at least not at our scale. We have lots of issues in the GST regime because of that, where we transfer credit from one state to another state. We deem one person to be multiple persons across different states. We have peculiar rules with respect to international supplies and receipts. We have very peculiar rules with respect to certain industries. So, but I think at a global level, we must be appreciative of the fact that GST has been very successful in being able to reduce the complexity of the tax regime which used to be there previously, with excise, sales tax, octroi, and all of those other issues. We must acknowledge that this GST is not a simple GST. Okay, and these are things, and we are at a very early stage of our GST evolution. So I expect over the next 10 years, things to, and I'm not saying 1 year, 2 years, I'm saying 10 years at the minimum, for there to be a cycle where these GST laws which have been implemented get adjudicated, get tested, get streamlined, and we have data to show what needs to be done for the purpose of being able to improve it. I still feel it's a step in the right direction with respect to what we are doing, but the complexity of the business added with the complexity of our GST rules is always going to have these kind of things in the entire system. And that's where I think we need to kind of acknowledge, but at the same time, try and find a way by which we keep improving the system so that we are able to reduce the friction for all the taxpayers.
Well, that same question to you, Abhishek. I'd like to know your view on how you're looking at it. GST has no doubt been a success story, but why are we still trying to iron out these wrinkles 7 years later? If indeed, and I must sort of put that in perspective, if indeed these are unfair tax notices, so for all you know, these are going to go through in court, and this is monies that companies had to pay.
I think when we are going and taking these matters to court, what we have been arguing is whether this provision is or the notice is manifestly arbitrary. And when I say that with full responsibility. Now, if you talk about insurance companies, the question which arises is that in that entire transaction, is there an evasion of tax? If you talk about the gaming industry, the question comes on the valuation. And when we ask this question that whether the valuation for online gaming companies or for casinos could be different from what is prescribed in the scheme, the answer is clearly that there is an exception which has been created for online gaming companies. And hence the questions which are there before the courts to test the constitutional validity of these provisions and these notices is this: whether there could be a differential treatment for online gaming companies when it comes to valuation. For all other service providers, you are taxing my revenue. But for online gaming companies, you are creating an exception. And when you talk about actionable claim, can the valuation go to an extent where the money relates to participant to participant? Similarly, if you see about these credits, a lot of been talked about insurance companies and other, and more than 10,000 of such notices on credits have been issued. The question is whether there is evasion. That is one. Secondly, even when we talk about the block credits, and that's what we are arguing before Supreme Court also, that there is an exception which is being created under Section 17(5). And hence, whether these exceptions are good or arbitrary, or whether there is lack of intelligible differentia, will all have to be tested based on reasonability, vagueness, and hence Article 14 and 19 will come into play for a lot of these provisions, which are exceptional, which are beyond this scheme.
All right. So these are going to be very important test cases as they go into court. Meanwhile, for companies, this is something they have to budget for as we come into this period, October, November, December, where litigation is going to pile up. Remember, their deadline for adjudication is also 31st December. So interesting period ahead. Thank you so much, Badri and Abhishek, for joining us on the show. Pleasure as always.
Thank you so much.